Okay, I think it's time for us to get moving with the presentation. Good morning, everybody. My name is Gary Falk. I'm an attorney with Bodman PLC, and I'm a member of the Workplace Law Group. I want to thank you all for joining us for today's presentation, which is entitled, Can Employees Avoid Work, Avoid Discipline, and Get Paid? This is going to be an overview and a question and answer session to help you navigate the challenges uh, of working through this crisis with the restrictions that are in place and the health issues that are in place right now. I would also like to thank the Construction Association of Michigan for helping to coordinate the presentation, particularly Jim Olashansky and Vicky for working with us and coordinating this. Uh, there will be a link to the recording that we are going to be working with Cam on for folks that aren't able to attend, or if you want to go back and play it again, and if there's something that you think you missed. And there's also going to be a link to a takeaway sheet with some guidance. On the phone with me, I have several members of the Workplace Law Group. I have Rebecca Sagis-Prabuha, John Belo, and Aaron Graves, the chair of our group. All of us have been dealing with COVID-19 issues almost exclusively over the past few weeks, which is no surprise. This is going to be a joint presentation, and our format is going to go through a PowerPoint and give you a quick overview of some of the issues that employers are facing in the new legal landscape. And then we want to save time to open it up to your questions and respond. We may not have time to respond to all your questions. However, our contact information is available. It's at the bottom of this PowerPoint, and it'll be made available to you as well with takeaways. We have a lot of great guidance on COVID-19 on our website, bodmanlaw.com, and it's very easy to find it. You just click on the COVID-19 tab. My role to begin with is going to be to provide a brief overview of the materials. Then I'm going to pass it off to my colleagues to talk about certain aspects of the legal landscape and to fill in some of the meat on the bones that I'm going to go over. The pandemic, as you know, has had a wide-ranging impact on work and work laws, and the local and federal responses have been rapidly changing and expanding legal obligations for employers, everything from trying to define who is able to work in this environment and what obligations that they have to their employees. Some of the issues we've been busy providing guidance on to clients deal with things such as leave, Michigan Paid Leave Act, how that's affected, traditional family and medical leave issues. If you were previously covered by the Family and Medical Leave Act and required to give unpaid leave for qualifying conditions, how the ADA affects employers with regard to COVID-19, whether there are any accommodation requirements. And as you know, under the ADA, sometimes leave may be a reason for accommodation. Additionally, there's a new federal law, the Families First Coronavirus Response Act, that provides paid leave obligations for employees on employers with employees of 500 or less. It comes in two forms: paid sick leave and a new Emergency Family and Medical Leave Act. We'll talk a little bit more about that later. We've also been addressing a lot of employer concerns about staffing and attendance issues, how to get employees that are permitted to work for critical infrastructure employers into work and not game the system on getting benefits. Now, there are benefits in place for people that legitimately qualify for them, but as we'll talk, and as you've probably seen, there are some employees who either honestly or maybe dishonestly are trying to avoid work out of fear or because they feel that they're going to get more money by sitting on the bench and just sitting at home and getting unemployment or other benefits. Another issue that we've been seeing a lot of is questions regarding health and safety issues in the workplace. Under OSHA, there's a general duty to provide a safe workplace, and OSHA has also issued guidance on preparedness and response for employers that are operating. And the governor's executive order has actually required those employers that are operating to have a response plan. We'll talk a little bit more about that later. Some other issues that we've been getting questions on are HIPAA concerns, uh, medical testing requirements, and uh, daily questionnaires on health issues that are being mandated by some of the counties. You may be aware that the governor has issued numerous executive orders, and I'll just give you a brief overview of some of the executive orders that are out there that you need to contend with. Uh, Executive Order 21 shut down most of the businesses in Michigan, but permitted essential businesses to continue to operate with certain essential employees. That was expanded through Executive Order 42. And right now it's been extended through the end of the month. Although that we're hearing from the governor, her speech yesterday saying that she feels that there's going to be another extension of that order. So we're waiting to hear on that. We may hear on it on Friday. Executive Order 24 that came out of the governor's office expanded unemployment and made employees eligible who are suffering from certain health conditions that were not otherwise eligible for unemployment in the past. Now that technically expired at 11:59 last night. We don't know if it's going to be extended. We're waiting to hear on that. And there's also a federal law, the CARES Act, that added to the length and the amount of the benefit. And we're going to hear a little bit more about that later. Finally, I want to talk about Executive Order 36, which is very important. It protects employees who cannot come to work because of COVID-19 related concerns, and it prohibits employers from taking retaliatory action against employees who will not come to work or for failing to document the reasons for their not coming to work. So with that, I want to turn it over to my colleagues. We're going to have a short PowerPoint presentation to go over many of these issues that I just gave you a brief overview of. And then after that, we're going to have a question and answer session. You can raise your hand using the WebEx function, and our coordinator can then unmute you and allow you to ask the question at the appropriate time. There's another way to ask a question. It's a Q&A chat button. You can ask it through that. And you can always, especially if you're calling in, you won't have access to that. You can always email us the question. And to email questions, I'm going to ask you to send that to jbelow, B-E-L-O-W, @bodmanlaw.com. That's John Below, who's on the phone with us. We don't get an opportunity to answer everything, or if you need materials that we discuss, feel free to contact us at any time. Our contact information is at the bottom of this PowerPoint. John, I'd like to turn it over to you to talk about some of the issues that I've just gone over and fill in some meat.
Hey, thank you, Gary. John Below here. Good morning to everybody. Pam, if you can advance to the first page of part one, great, that's it. One of the biggies, if you will, that came with Governor Whitmer's extension of the original stay-at-home order is the requirement that each business that's open and operating essentially, well, that would be mainly critical infrastructure workers, or the phrase that's often used on the streets is we are essential. and hence we are continuing to operate, is the requirement for a workplace safety and preparedness plan. The plan requirement includes that you post it at your work site. In some cases, that's going to include more than one site, depending on the places your employees are, such as a corporate office, but as well as at a potentially at a mobile job site or mobile office, where you might otherwise put posters required for equal opportunity or discrimination, things like that, wage and hour. Um, Prior to this particular order, there was a similar order issued out of Oakland County and Washtenaw County. They were a little bit ahead of the game. That is before April 9. So some folks were already adapting to the plan requirement prior to the April 9 Executive Order 42. The requirement addresses different work situations involving risk, what I call risk ratings: low risk, medium risk, high risk, and very high risk. The very high and high risk tend to be in the medical field, relative to treatment of people with COVID-19 or probably COVID-19 symptoms that you can see. And in the case of very high risk, where there's airborne pathogens in the daily operations of that particular business. Now, what these plans tend to do, obviously, is instill, require safety, but also instill some confidence in the employees that continue to work. That that things are being taken care of with respect to spreading this virus. So it obviously is trying to address the safety of the employees, but I think that one of the more important aspects of this is that this part of the executive order is the one that will probably continue well beyond April 30. And I think we're already hearing grumblings and statements to the effect that the stay-at-home order is going to continue to perhaps mid-May. But we believe that this particular part, that is the plan, workplace safety plan, and the implementation of such a plan in various types of businesses, is one that will extend beyond May 15, because this will be a bit of the new normal for a while, we believe. Rebecca Segay Scribuja is working on this as well as I am a lot, and we're preparing plans for clients to fit their particular risk situation. Sometimes clients have more than one. Rebecca, you want to give some of your insights on that?
Yeah. So your baseline is going to be that you need to be addressing your cleanliness and your social distancing efforts. And so you're going to be wiping down common areas. You may be adjusting shift schedules so that employees are allowed to maintain at as frequently as possible a 6 feet distance between each other. You also need to address what you're doing in terms of isolating sick employees. And so that means doing a daily screening. Like we said, some of the counties have their own public orders mandating that. But you're doing a daily screening, going through the typical symptoms that employees with COVID-19 would be suffering and removing them from the workplace. There are exceptions for the healthcare industry, and so that's not going to be applicable here. But in general, if you have an employee displaying symptoms, they need to be removed until they have negative test results or they are symptom-free for usually about 7 days. And then you're also going to maintain an explanation of the workplace flexibilities and your benefits that employees are going to be eligible to receive. And so the workplace flexibilities typically means what you're doing to adjust your attendance policy. Are you going to suspend it? Are you going to have exceptions to it? And what do employees need to do to qualify? And then the potential benefits, that's going to be the leave that Gary mentioned at the very beginning. So we've got FFCRA leave, which would be paid leave. And then we also have your typical unpaid FMLA leave if you're an employer with 50 or more employees. And then under the ADA, you may have leave as reasonable accommodation if the employee asserts a disability. And so this is your baseline. These are the things that need to be addressed in your plan that every employer that is continuing to operate needs to have. And then if you are subject to a medium risk, which usually means that you have employees who interact with the general public or who are unable to maintain social distancing, then you have to implement a supplemental preventative measures. And so frequently that means physical barriers or systems that in some way minimize employees' interaction or close interaction with others.
Thank you, Rebecca. I think we can move forward regarding another potential new development, Pam. Sorry about that, folks. Rebecca and I tend to go back and forth between the two workplace safety slides. Pam, if you can scroll toward the benefits. Yeah. We're hearing that there's a potential Work Health Coverage Protection Act that will be introduced soon that may allow for federal government to subsidize or pay for premiums for employees to stay on their employer's healthcare plan after a layoff or a reduction in hours that occurs after March 1. I think this simply ties with the attractiveness, if you will, of not working as opposed to working, and what may motivate and color the way employees view going back to work or not, when they could have up to 15 months of free but employer plan healthcare benefits. Pam, you can go forward to the next slide.
Okay, Pam, if you could go forward to the next slide. This is Aaron Graves. The next slide deals with employee leave options and fits right in with what John was just talking about as far as employee incentives not to work. The first part of that is unemployment compensation benefits. There is Executive Order 2024, which expired at midnight last night, that provided benefits for individuals who are immunocompromised, individuals who displayed COVID-19 symptoms, or who had recent contact with someone with a COVID-19 diagnosis, or if they needed to care for somebody with a diagnosis, or they were subject to a family care responsibility as a result of a government directive. The one that we're all dealing with is, the kids who are out of school and driving you crazy at your house. So now that expired on last night. Do we know what the unemployment agency is going to do regarding that? No, but I can tell you that it's highly likely that they are going to continue to grant benefits. That does not mean that we shouldn't be notifying employees that we are going to deny benefits for them to return to work, and also that later on the unemployment agency may look into these claims and deny them on a later date, and then force employees to pay back the money. I've seen that before in the future, and I'm sure many of you are in the past, and I'm sure many of you have as well. We see in the future. The next key issue is the CARES Act. That increased the amount that employees can receive in benefits by $600 a week. So it went from the maximum state amount of $362 per week to a maximum of $600 per week. The employee gets the $600 even if an employee only receives $1 of state unemployment. That continues for 39 weeks. It actually goes on till July 31st. Then once the employee's state unemployment benefits runs out after 26 weeks, then there's an additional maximum 13 weeks of the $600 federal benefits alone. And that will expire on December 31st unless there's some change. Also, we have the FFCRA, the Family First Coronavirus Response Act. That provides paid leave under the Emergency Paid Sick Leave Act and the Emergency FMLA. Essentially, the EPSLA, that provides benefits, and that's 80 hours of benefits over 2 weeks. And that would be for the quarantine or isolation order. That doesn't apply if you're an essential employer. If you're advised to self-quarantine due to concerns related to COVID-19, that's if you have a doctor's note that says, hey, you've been exposed and you need to stay home. Also, you would be entitled if you're experiencing symptoms of COVID-19 and seeking medical diagnosis. That's the employee comes into work, they've got a fever, you send them home, tell them to get a diagnosis, and they actually go and seek the diagnosis. If you're caring, the other time is if you're caring for an individual who's subject to a quarantine or isolation order or advised to self-quarantine due to concerns related to COVID-19. Again, you should have a doctor's note for that. If you're caring for a son or daughter whose school or child care provider is closed or unavailable due to COVID-19 precautions, all the schools are closed, right? Keep in mind that it has to be a son or daughter, and also that there isn't some alternative daycare available, so that we need to get certification on those. Or if they're experiencing any other substantially similar conditions specified by the Secretary of Health and Human Services in consultation with the Secretary of Treasury and Secretary of Labor. There has been nothing has been specified by the Secretary of Health and Human Services yet, so we don't know what that's going to be. If the employee isn't a full-time employee, then you would prorate it based on the amount of employee that the amount of hours the employee typically works. The paid leave for the first three reasons that I set forth, that is going to be full rate of pay, capped at $511 per day. For the later reasons, that's paid at 2/3 of the employee's rate of pay, capped at $200 a day. Rather than go through all that detail, we are going to be providing a takeaway sheet at the end of this. And that'll be laid out in that takeaway sheet, so you have guidance on that. The next leave that's available under that, the FFCRA, is the EFMLA, the Emergency FMLA. Under that, the person gets up to 12 weeks of leave to care for a son or daughter whose school or child care provider is closed or unavailable due to the COVID-19. The first 2 weeks are unpaid, so there's an overlap with the EPLSA. So the first 2 weeks should be covered by the EPLSA. The next 10 weeks are covered by the Emergency FMLA. The Emergency FMLA, that falls under the lower cap, so it's 2/3 of the employee's regular rate of pay, capped at $200 per day. Make sure that you get documentation on these, because you get a full tax credit for the amounts that you're paid under this, or months that you pay the employees under this. As far as employers who have to pay this, there are some exceptions for employers who are under 500 employees, or under 50 employees, I'm sorry. But generally, if you're under 500 employees, you have to pay these benefits under FFCRA. The next element is the Executive Order 2020-36. That essentially says you can't discharge or discipline an employee who's been sick due to COVID or has COVID-related conditions. And you can't terminate an employee or take adverse action against an employee because that employee doesn't provide you with documentation of the need for a leave. Obviously, that's very problematic if you're trying to get tax credits and the employee won't provide you the documentation, and you can't take adverse action against the employee or threaten them with termination if they don't provide you with the documentation. So you aren't going to threaten them with termination. What you're going to say is, To be eligible for the benefits for the paid leave, you need to provide me with the documentation. So hopefully you can get the employee's pocketbook to drive the decision making. Finally, on the Family and Medical Leave Act and the Americans with Disabilities Act, you can't forget about those. Number one, it's important to remember the FMLA, because if the person takes emergency FMLA, that will count against their FMLA, their regular FMLA entitlement. Also, an employee may just have a regular FMLA condition where you need to provide them with leave. Don't forget about that. Otherwise, you might just run into a regular FMLA violation. You also have, under the Americans with Disabilities Act, a requirement that you provide leave if the employee has or provide, I should say, a reasonable accommodation. And there has been EEOC guidance that says if an employee is at risk, meaning that they have for example, I've got if the person has a immunodeficiency, then that you have to provide that person with leave rather than requiring them to come into work. So don't forget to ask those questions before you simply deny a person leave. Could you go to the next slide, Pam? There's a little bit of a delay. The slide changes. There we go. Gary, did you want to take this, or do you want me to?
Yeah, I can take it. And then maybe you can chime in and be a little interactive here. So this is a chart that we put together that kind of lays out the issues. In the first column here, you have what an employee may get if they return to work. Let's say they're making $15 an hour, 40 hours a week, $600 a week. They're getting their employer paid health care. They're getting retirement contributions. If you're signed on to benefit, multi-employer benefit plans, you're making the contributions to those benefit funds. And they're getting long-term security. If they have a job, you have a viable business, you're hopefully making money. And that's scenario one. Scenario two, employees who are seeking to stay home, even if they're just afraid to come to work, with the enhanced federal benefits of $600 in federal unemployment for at least for a period of time. They may be making the 362 plus 600, 362 is the state benefit, so that's $962 to stay home. So there's a financial incentive for employees to want to remain on unemployment for the next 30-something weeks. I think the maximum time available with the federal extension is 39 weeks. Then there's the issue of health care. Are they going to continue to receive health care or not? Now, with some employees who are receiving health under a union health and welfare plan, you're going to have to look at your plans. But I know that some of them provide for employees who are off work to have banked hours and that they can still continue to receive their health care. Other non-union employees or even union employees who don't have those kind of benefits may be subject to losing their health care or at least having to pay COBRA. That's where John mentioned that the federal government may be requiring a subsidization of that, but right now that's not the case. Then they're not getting retirement contributions, and perhaps they're not getting any long-term security because we're not working. Another option, depending on how your business is run and what work you have available, might be to structure it so that there's an incentive for employees to come to work at least part-time. Because if you do not make more than $542 in wages and you have a reduction in your hours of more than 20%, you're going to qualify for some state unemployment benefit, which will also permit the employee to get $600 in federal unemployment. You'll have an employee who's working, and they'll actually end up being better off financially, and they'll have their health care contributions. they'll have their retirement contributions and the long-term security of having a job. Pam, if you could move to the next slide, I turn it back over to Aaron to maybe talk about the strategy here on what we can do to encourage employees to come back to work, given that framework that I just went over.
Thanks, Gary. Yeah, the part-time work, and I'll talk a little bit before the slide moves over, but I mean, the part-time work is one of those great options that if that works for your business, where you can actually give the employees some security and actually bring them up above what they would make on unemployment without additional cost to you. Some of the other things that you can do is communicate with your employees about to try to encourage them with both a carrot and a stick approach to return to work. First of all, if your employees are sitting at home 3 o'clock every day and watching the governor scare them to death, it may not be that easy to get them to come back to work. So you need to give them a notice. You could make it patriotic. If you look at what the Department of Homeland Security has said, they have said that those employers who are essential employers and their critical employees have a special duty to come to work. Those are things that you can talk to, and that may make a difference for some of your employees. And on the stick side of that, you can make a strong message to employees to say, hey, look, if you don't come to work, it may have a dire consequence for our business and your long-term job security. We're going to deny your unemployment. Even if you're granted unemployment and the UIA is just granting everything willy-nilly, in the future, the UIA is going to come back and revisit these and may make you repay the money. If the person is just afraid of coming to work and they don't want to give you any documentation as far as reasons, then you can notify them that you're going to apply the attendance policies and that attendance termination, or they may apply, or they may be considered to have abandoned their job. They're going to make clear that they're going to lose their health insurance, and that even if they're on unemployment, they're going to have to pay that on COBRA and what the costs are. Obviously, you have to look at your labor contract to make sure you're following that. Make and notify employees that if FFCRA is available to them, that it's only going to be provided if they provide satisfactory documentation. You can notify employees, especially if that employee happens to be an FMLA abuser, that if they take that EFMLA, that's going to diminish their FMLA down the road. They're not going to have those weeks off to be able to take later on this fall. Also, you can talk about, the measures that and that'll be in your required COVID-19 preparedness plan. These are the safety measures that we're taking to make sure that you're safe when you're working. If you continue working, you're going to have job security. If you continue to work, you're going to have these financial benefits. So you really want to make a message. You want to send a strong message to your employees to try to get them to come to work. You go to the next slide, or actually go to the next slide, and then we can open it up to discussion, because I think that next slide works really well with some of the questions I anticipate we're going to get. Next one, Pam. And then I'll let Pam, do we have any questions out there?
Yes, we do. You want to cover this slide first?
Go ahead, Rebecca.
Okay, I was having trouble unmuting. All right, one of the most frequently asked questions that we receive is, what do you do when an employee refuses to work? And so we've kind of outlined your steps that you'll want to take for your internal documentation. You first want to ask the employee to submit a written statement articulating why they are refusing to work. And then you want to analyze that statement to determine whether or not the employee is entitled to certain benefits or certain protections. And so if the employee cites as their reason for not working a qualifying reason under the FFCRA, or a serious health condition under the FMLA, or a disability under the ADA, then we need to analyze whether or not they're entitled to leave. And then if they're not entitled to leave, you want to see whether or not they're asserting something that should be considered under the NLRA or OSHA. So are they contesting that the workplace would cause them serious injury or potential death? And if they're doing that, then we want to refer back to our plan, our preparedness plan, and explain all the ways in which we are ensuring that the workplace is safe. And then they could also be asserting a reason that would entitle them to unemployment compensation benefits. And like Erin said earlier, Executive Order 24 did expire last night, but we're anticipating that the UIA will continue to approve benefits. And so if an employee is eligible for unemployment benefits, it doesn't necessarily mean that they're entitled to leave. If they are asserting a reason that would provide them benefits, but not a reason that would provide them protections under the FFCRA, they're not going to be entitled to reinstatement. They may not have any job security. And so that analysis needs to be done a bit differently. If they're talking about a general fear to continue in-person work, again, refer to the plan, explain what we're doing to protect our employees, and then they have the option of perhaps going on unemployment. And again, that's not going to offer them reinstatement rights. Their ability to collect unemployment is compromised, and we may be able to eventually assume voluntary resignation. But before you make a decision, you need to assess your comparators, determine what you have done for other employees. And so you need to be consistent. And so that's looking at your protected characteristics under state and federal law and making sure that you are not treating any employee differently in your approval or denial of leave, because that is going to be considered a term or condition of employment. And then you're going to go through the incentives that Erin went through. So you're modifying the incentives, you're asking them to come to work, and you're giving them all of the reasons why. And then your last step is going to be to identify your decision maker. Are you going to have the employee decide not to come, or are you going to make the decision for them? And so we had a client who wanted their employee to go off on unemployment because the employee was otherwise entitled to leave under the FFCRA. And they did not want to claim the small business exemption, which they thought they were entitled to, but wanted to make the employee make the decision for herself. And she did choose unemployment because we did a letter that made unemployment sound desirable to her. But that way, the employer did not enact what could be construed as an adverse action. It left the decision solely in the hands of the employee.
Okay, Pam, do you want to address some of the questions?
Sure. So first question we have is, I have employees that went on unemployment when we had no work. Now we have work because we are essential. When I called them to come back when we had work, they refused because they are making as much or more money sitting at home versus coming to work. What are my rights?
That's right. Thank you for the question. I mean, that's right in line with what we're talking about here. That's the problem that we're trying to help you address. So your right is to notify. First of all, you should issue a return to work letter notifying that employee that work is available for them. That gives you a lever to deny unemployment. That's not to say the state isn't going to deny them or grant them unemployment anyway, unfortunately. But what you need to do is create that strong message that's appropriate for your business and your employees. We all know how difficult we were in an employee shortage before this all started, right? And now our employees don't want to come to work, and we've got work for them to do. So I would recommend that you think about a message to those employees saying we're going to deny your unemployment. Go through the elements laid out in Rebecca's slide here to make sure that the person doesn't have some protection under the FFCRA or the NLRA or some other reason. And if you boil it down and get rid of all the excuses, and it's only just, I'm not returning to work because I can make more money on unemployment, eventually you should win that claim. And you should be able to terminate that employee's employment under your attendance policies if you need to. Anyone have anything to add on that?
Yeah, and then the other issue is if employers are in a position where they think that they're going to be calling back employees to avoid that situation, you may want to put together a communication regarding the callback and laying out the reasons why they need to come back to work, obviously without threatening anybody who has a legitimate reason for staying out, but going through that analysis and educating them that if you come back to work, you'll have your health care. If you don't, you're going to have to go on COBRA, and it won't be paid if that's unless you have a collective bargaining agreement. You'll have to follow that. The other issues that you want to address are long-term job security. That the unemployment benefits are temporary. That the viability of the company depends on employees coming back to work and doing the job, and really educating them. It's not about the extra few $100s a week for a short period of time. It's about coming back to work and having a good paying job for the long term. So you got to balance your messaging with employees who have legitimate reasons not to come back, but to set that up rather than just have employees telling you, nope, I'm not coming back, and then trying to dig out at a later date. And now I understand that may have been water under the bridge already with some of the employers, and then I think you need to do the education on a case-by-case basis, and sometimes take a hard position.
Yeah, this is John. I think Aaron pointed out earlier too that the unemployment agency can be awfully slow in figuring things out. In many cases, they do, and it could be many months later that they go back after the employee to return the unemployment benefits because there was clear indication that there was work to do and that they were not laid off, essentially. So they were then disqualified as of that date. And, the UIA will figure it out eventually. And that's a very painful, uncomfortable experience. At least I've seen by watching from the distance on behalf of the employer. That's a painful situation for many employees that we're talking about.
Okay, next question is, are we talking about essential employees only? What happens when we are open and my restaurant owners are having a hard time getting their employees back to work?
Well, I think right now, this is John again. I think, right now, essential or critical infrastructure workers, as under the guidelines, are the folks that are dealing with this on a day-to-day or every few days basis. I think that the issues, however, are going to continue when we go back into a return to work phase or a staged return to work phase. I don't know what my colleagues think about that, but I think certain elements of these things we're discussing today are going to probably continue for a good part of the year, if not beyond that.
Yeah, I can add on to that. Once the, Executive Order 42, which is basically the stay-at-home order, that is purportedly going to expire at the end of the month, right? We all know that it's not going to, it'll expire, but we're going to have something new in place that's maybe a little less restrictive. Once employees are no longer, once an employee comes out from under the stay-at-home order, they're going to be treated just like your critical essential employee. So all of this same material is going to apply that we're talking about today. It's going to apply to them the same way it applies to a essential critical employee currently.
Okay.
Sure. I guess it's hard to say how long people will be claiming the COVID-related statuses, but you get the feeling that people will be claiming them long beyond the time that it's a real problem on a wider basis.
Agreed. I think that people will claim it as long as they can get money for not working.
You said it better than me.
And I want to point out also that if you are a company that has the ability to telework right now, and you have employees other than your critical infrastructure employees, being able to telework is also a disqualifier, because if you have that work available and employees are refusing to engage in the telework, that should be a disqualifying reason under unemployment as well. Pam, do we have more questions?
Thank you. One of the questions is, what documentation or proof can an employer request to support a request for time off under FFCRA or FMLA?
Rebecca, do you want to handle this one?
Yeah. So there's a difference between what an employer can require to be able to approve the leave and what the employer can require in order to receive the tax credit back from the IRS. So to approve the leave, you're going to want to ask for a doctor's note. Oftentimes, employees are saying that they're unable to provide the doctor's note because the healthcare system is so overwhelmed at the moment. Start by asking for it. If an employee legitimately, asserts that they're unable to provide it, you can ask them for a written statement, but certainly maintain that you need the documentation for as long as possible. And then it depends on the reason for the leave too. And so if the reason that they're asserting leave under the FFCRA is an executive order, we have copies of the orders. You don't need to require that from the employee. If it's an order to self-isolate, that's going to be coming from the doctor. If you're requesting leave for childcare, you're going to ask the employee to complete a written form where they're going to identify their children, their ages, and the school that is closed. And so all of these should be made in a written format, and we have an FFCRA request form that we can disseminate should anyone follow up with us, because you want to maintain the documentation because you're going to be giving it to the IRS to get your tax credit. If they're taking leave under the FMLA, then they need to provide the certification of a serious health condition from their healthcare provider. And so that is going to be your typical DOL guidance as to the documentation required.
Okay, next question. Under the EPSLA, it appears that all employees that are unable to work or telework must be paid for quarantine for 80 hours due to the stay-at-home order. We are performing some essential services, but not with all employees. Can you talk about this?
So the stay-at-home order does qualify under the employee paid sick leave provisions as a qualifying reason to receive the 80 hours of pay, which are, by the way, capped at $511. Now, you only qualify if there is no work available. That is, like if they're not critical infrastructure employees who are permitted to work and you have work for them, or they're not able to telework. So if they are off work due to that order, then they do qualify for the paid sick leave. But the caveat is, if you're critical infrastructure, including being designated by a critical infrastructure employer as a critical supplier, and that employee is essential, or they're able to telework, or also certain employees who are required to perform minimal operations work. For example, the person has to come into your office to process payroll, might be somebody, or somebody who's getting your computer systems and has to come into your office to do that. Those might be minimal business operations folks that are excluded.
I agree with what Gary said. I just want to clarify one thing, because just in case the person lodging the question is trying to get at something else. If you have some people working and other people are not, those people who have been laid off, they are not eligible for the EPSLA unless they're recalled to work. Once an employee is recalled to work, then they would be eligible for the EPLSA. But if for laid off employees, that's not a benefit they're entitled to, then the laid off employees are instead entitled to the unemployment.
That's absolutely right, Aaron. Whether or not the layoff was before the EPSLA requirements went into effect or after, if they're laid off for lack of work, then they are not qualified for the benefit after that layoff.
Okay, next question. If a company has successfully implemented telework, how or when can an employer require workers to report to an office environment?
Well, I think you're going to need to look at what the state stay-home orders or currently look like, and then what they look like in the future to determine whether the company is lawfully permitted to operate in an office environment. And if that's the case, then you as the employer can determine the employee is required to come into the office to work. Now, in order to do that, you're going to also have to have a response and preparedness plan to ensure that you're taking steps to have a safe work environment. So that's the second piece of the pie is whether you can, first is whether you can require them to do it. You have to look to the orders. And then two, how can you do it, which is your safety plan.
Keep in mind that this was stated earlier on, but it was kind of at the beginning and things get lost. But if you're operating with employees at your place of business, or even if those employees are working out in the field, you need to have that COVID-19 preparedness plan. We have a form plan that we can provide anybody if you email one of us, and our contact information is at the end of the presentation and also in the takeaway sheet you can get after the presentation. Any other questions, Pam?
Yes, it's regarding PPP loan program rules. It says, if I have to call back employees after receiving funding, the business is non-essential and unable to work under governor's orders, but the employee makes more on UIA, can I or should I issue a temporary pay increase?
So we have our banking guys that are better experts on the PPP. If somebody wants to take a shot at that on the panel, then go ahead. I mean, that may be a feasible strategy. But if Cam is interested, reach out to Cam, let them know that you're interested in a PPP presentation, and we can get our banking guys on the line, and we'd be happy to do a presentation, a different presentation to address PPP issues.
Yeah, and I know that we aren't the experts on this, but I did have a conversation with one of our corporate attorneys about doing new hires with PPP money. And so I think that this could be considered a bit of a comparator to that. Your concern is making sure that you don't drop below your payroll level and making sure that you don't decrease employees' earnings by more than 25%. And so increasing their earnings, certainly isn't going to disqualify you for forgivability, but it likely won't mean that the increased earnings are going to be part of your forgivable loan.
Yes, and the other thing that I know enough about it to be dangerous, but I was on a phone conference with one of my clients and one of our corporate banking guys, in that you can't just hire everybody on the last day and then be exempt from or exactly have all the loan forgiven. They're taking a rolling average of your FTEs over the period. At least that's my understanding.
Yeah, and that's important, Aaron, because it's not just about a percentage of money that's going towards payroll and other required elements to be forgiven. You also have to meet that FTE requirement. So if you bump everybody up just to meet the forgivable loan requirements as far as how much is going to payroll, but you have less FTEs, you still may fall into a non-forgivable portion. But again, the banking guys would be better to answer that question. But I think you have to look at both the amount going to payroll and the number of FTEs.
Yeah, I guess I can add that, to the extent that a percentage increase is provided to ensure that employees are back to work and ready for the ramp up, if you will, for business, two things come to mind. Well, one, they're not supposed to be receiving unemployment benefits while they're receiving compensation, which is assisted by the PPP. And then there may be a small percentage of that amount that you bumped up that is not forgiven, but then it's a loan that's what, 1%. You know, as often is the case, it's a business decision about whether or not, you know, you leave a little bit out of the forgivable category to ensure success when the business is getting ready to ramp up. So I guess that's all I wanted to add on that.
Okay, one last question. If we have allowed the employee to claim they are laid off, how do we notify the UIA that we have worked for them now?
Well, like I said earlier, you want to have that letter that you send them, the recall letter, and then you may have been okay with the claim at one time, right? Early on, the claim was fine, but you should notify the UIA that subsequently work did become available, and you can do that through the MyWham account. Rebecca's been fiddling with that, I know from our discussions, but it can be very difficult to navigate. Do you have any guidance on that, Rebecca?
Yeah, you can do, I believe, a request for redetermination, and the client that I was working with had trouble with their MyWham account, and so you can do it the old-fashioned way and fill it out and fax it to them. Getting in contact with the employer ombudsman is exceptionally difficult right now, and you know, depending on the setup of your online account, keep in mind that, you know, the forms are available on their website and you can fax them.
Yeah, they're struggling with processing just about everything right now.
And keep in mind, John said something that kind of triggered me a little bit. I had a situation some years ago where an employer called me up and said, "Hey, I've got this employee. They're working light duty, collecting workers' compensation and unemployment. Can I fire him?" I said no, because I want to figure out how to get 3 paychecks too. So ultimately, if you think that you have employees that are doing that, in other words, taking advantage of the FFCRA benefits, otherwise receiving pay and receiving unemployment, you should notify them that that's fraud, and the state will go after them for more than the amount that they're getting paid.
Yep.
So I believe it's actually triple damages, right?
It'll take a little while, but yes.
They will get them.
That's all the questions we have.
Oh, I have a quick one that just came in through chat. And so they're asking, what are the minimum number of hours that an employee can work part-time and still receive unemployment benefits? And so I know that there are specific levels for the work share program. And that's talking about employees who are working between 15 and 45% of their typical hours. If you were just claiming underemployment, meaning you're not working as many hours as you were, I don't believe there's a specific number that you need to continue. The UIA will just do a determination of your gross wages and the percentage that you're now receiving in comparison to what you typically receive.
Right. There needs to be a reduction of over 20%, but there is no minimum number of hours for them to receive unemployment. For example, if an employee were to work 5 hours a week or 10 hours a week or 25 hours a week, you just can't go over, right? You have to go hit the middle ground. So there has to be more than a 20% reduction for eligibility, and then they can't make more than the $542 per week. And the employee should be eligible. The unemployment agency determines eligibility, not you, not us.
We do have one more quick question. Will email correspondence with employees be sufficient for record-keeping purposes for the documentation required?
Yes, just make sure that the employee's email address that you're using is the address you have on file. Or that you have confirmation that they've communicated with that email address. Basically, don't send them a return to work letter and then assume voluntary resignation if we don't have an indication that the employee is actually monitoring that email.
And we had one other very simple question that came in through chat, was asking about whether it's how the state and federal unemployment work, and the answer is yes. If you qualify for state unemployment, it is a $600 federal add-on. So if you qualify for the maximum 362, you get the 600 for 962. If you qualify for less than the maximum, you still get the $600. That $600 is not reduced.
Across the board.
Well, it looks like we've reached the end of our time. I want to thank everybody for participating. These are very challenging times, and everybody is facing their own unique challenges with their workforce and their type of business. We expect the legal landscape and the obligations to unfortunately become a little bit more complicated as time goes on and we start to move back to opening up the economy a bit. If you have any specific questions, feel free to reach out to us. Our contact information is on the presentation slide. We also thank Cam again for coordinating the presentation and for the opportunity to present to you. And we wish everybody the best in continuing their business, and hope everybody stays safe. And thank you, my fellow colleagues, for participating in this presentation.
Thank you, Gary. Yep.
Thanks, everybody. Thanks for helping out, Pam. Thanks for all the participation.
Yeah, great questions, everybody. Have a great afternoon.